I'd like to talk about unfair contract terms and how this applies to consumers. We get a lot of complaints about traders who refuse to indemnify consumers when things go wrong. These include complaints about some of the well-known brands. These are big companies who provide services over the internet. In many cases, they'll be based in a different jurisdiction a long way from the consumer. There's a certain amount of reticence by consumers to stand up and challenge the trader when things go wrong. For the consumer, it can be an expensive exercise, as the loss they have suffered may be disproportionate to the cost of pursuing the complaint. On the other side, the trader will have deep pockets and a team of lawyers already lined up to deal with this type of situation. The best way of informing consumers about the rights of consumers under the Consumer Rights Act 2015 is to give a case example and then explain how the law can be applied in the situation described. I'm going to refer to the Consumer Rights Act 2015 as the Act, for brevity. Part 2 of the Act deals with unfair terms. Section 62 in particular states, an unfair term of a consumer contract is not binding on a consumer. What this means is that in any claim by the trader against the consumer, or more likely, in any claim by the consumer against the trader, any term of contract which is deemed unfair is not binding on the consumer. The trader will, more often than not, point to the terms and conditions in an effort to escape liability. In a nutshell, this is wrong and probably unacceptable as well. It's long been the law in England and Wales, even before the passing of this Act. Standard terms and conditions are of little value in contracts between traders and consumers. The Act has gone further and, if you like, refined the law, fine-tuned it, and now we have section 62.4, which states, a term is unfair if, contrary to the requirement of good faith, it causes a significant imbalance in the parties' rights and obligations under the contract to the detriment of the consumer. This sounds good. Standard terms and conditions will, in almost every case, fall foul of this clause. I can say that with some confidence because complaints wouldn't get very far if the terms are properly drafted with this provision in mind. That is because, to even out the process, the clause translates into an obligation on the trader to almost invariably, in every situation, pay compensation or refund the consumer where there is a genuine bona fide complaint. Where the trader tries to avoid doing this to the detriment of the consumer, then the terms are likely to be construed as unfair. Okay, enough of abstract legal principles. Let's take a case in point. A consumer complained to us that he had made a hotel booking through a well-known company, in this case booking.com, which turned out to be a complete disaster. He had booked a room in a London hotel. The room turned out to be a basement, and apparently there was mould everywhere. A serious health hazard, and not to be regarded as a trivial complaint. Okay, Booking.com replied with a letter which I have shown. I've taken out the details of the consumer to protect the privacy of the individual concerned. The consumer, you will see, gets back a 4-page letter heavily reliant on standard terms and conditions. The meat of the complaint is dealt with at the end of the letter, which states, this is Booking.com, in this case the sole responsibility is with the accommodation, and I would suggest to contact them directly to see if they are able to offer compensation. Okay, let's look at the letter to see if the terms and conditions relied upon by Booking.com hold up to legal scrutiny. First off, it's important to remember the consumer has not complained to us that the terms and conditions are unfair. He does not have to do that. Section 71 of the Act states as follows. The court must consider whether the term is fair even if none of the parties to the proceedings has raised that issue or indicated that it intends to raise it. So even if the consumer doesn't know about it, we will look to see if the trader is relying upon terms which would be construed as unfair terms. Clearly, we need to know what these are before we can make an assessment. In the case example provided, we can do this easily. The terms and conditions that the trader relies on are set out. The reply is made by reference to numbered paragraphs. Paragraph 1 talks about Booking.com and the services it provides. Basically, it tells us Booking.com are an intermediary only. They tell us they don't actually provide the accommodation, and the contract the consumer makes is with the hotel itself. Paragraph 2 of the letter sets out the terms and conditions relied upon by the trader, which makes this point. Now, what does the Act say about this? Well, Section 64 of the Act states, a term of a consumer contract may not be assessed for fairness under Section 62 to the extent that it specifies the main subject matter of the contract. So, effectively, Booking.com could argue that the contract was not to supply accommodation, and this way escape scrutiny about fairness. The law has laid down specific requirements before this argument can be properly raised. It's a little bit complicated, but what this section is telling us is that if the actual supply is being argued or submitted to be unfair, that precludes the court from an examination as to whether the term of contract is unfair. Okay, well, in order for that to be disapplied, the law has laid down certain requirements. This being subsection 1, which excludes a term from assessment under Section 62 only if it is transparent and prominent. In this case, whether it was transparent and prominent, i.e. Booking.com were not providing the accommodation, it's a question of what an average consumer might be expected to know. What we look for is what the average consumer might be expected to know. If the average consumer might not be expected to know that Booking.com were not actually acting as an intermediary during the booking stage of the contract, then the contract terms do not escape assessment. And in that situation, the court or the tribunal may well go on to find that the term is an unfair term, and consequently the trader may not be able to rely upon that. So in the world that we have over the internet and the business model that's been set up by Booking.com, it may well not be sufficient to say they do not provide the accommodation. Okay, moving on. Booking.com go on to say on page 3 that they are a Dutch company and only Dutch law is applicable. I'm very surprised. We can make short shrift of this. Regulations EC 593/2008, in short, it's a European directive, sets out basically whether a party is entitled to rely on an exclusive jurisdiction clause. Now, I have copied and pasted the relevant provisions onto the screen. As you can see, an agreement between the parties to confer on one or more courts or tribunals of a member state exclusive jurisdiction to determine disputes under the contract should be one of the factors to be taken into account. In other words, the clause that has been relied upon by Booking.com is neither here nor there. It is only a factor to be taken into account. It is by no means definitive, and it would be wrong for Bookings.com to suggest that the jurisdiction clause has any application between the consumer and themselves in this particular instance. Turning back to the complaint by the consumer against Booking.com, the consumer was quite right to complain about the services supplied, and the trader probably cannot escape liability on the standard terms and conditions, all other things being equal. In summary, consumers are best advised not to hold back complaints. If they think something is not right, they should raise that in a complaint. Especially so if the only defence that the trader relies upon is the shield of standard terms and conditions. This is a shield which can be pierced, and it can be pierced very easily. Thank you.